Good evening. This is Point Blank here at KTN News, shooting from the Nairobi Serena. They say a rolling stone gathers no moss. As the Kenyatta purge on corruption gathers momentum, the Ethics and Anti-Corruption Commission this week carried out a manhunt, arrested and arraigned before court Mr. Ferdinand Waititu, the governor for Kiambu. Let us see what happened.
On a presidential trip to Namibia in March this year, President Uhuru Kenyatta told Kenyans residing there,
wewe kama unataka kuingiana na mambo ya ufisadi, tutapigana na wewe. You can be my brother, you can be my sister, you can be my closest political ally, you can be whatever you are. But you are an enemy of the Republic of Kenya, and we will fight you.
On Monday, 23rd, 2019, residents of the affluent suburb of Runda Estate woke up to a battery of EACC detectives and police camping outside and within Kiambu Governor Ferdinand Waititu's compound. For close to 6 hours, the detectives scoured every room in the house and all vehicles in the compound, finally carrying off tons of documents. According to the EACC CEO, Twali Mbarak, they were searching for evidence relating to irregular award of tenders valued at 588 million shillings to companies associated with the governor and his immediate family. Also raided were the office of the governor in Kiambu town and homes of 15 senior county staff. After being driven off to the EACC Integrity Center headquarters for the purposes of recording a statement, Waititu's lawyer, Ashiolia Biko, rushed to the High Court in Kiambu, applied and obtained an anticipatory bail of 500,000 shillings. It later emerged that Kiambu Principal Magistrate Brian Hemba, who granted the governor bail, had been on sick leave and should not have been at court. Having filed a complaint and asked the Judicial Service Commission to look into the magistrate's action, Hemba was suspended for gross misconduct by Chief Justice David Maraga and would immediately resign. A few days before the raid, Deputy President Dr. William Ruto defended his close ally at an event in Kiambu.
Biblia inatufundisha kila mtu atabeba nini? Kila mtu atabeba mzigo yake. Huyu baba yao asiwekewe msalaba ambayo sio yake. Aulizwe ya Kiambu, ile ya national government sisi tuulizwe.
Having viewed the evidence presented by the EACC, DPP Nordin Haji on Friday 26 July 2019 ordered for the arrest of the embattled governor, his wife Susan Wangari, and 11 others. After 2 days on the run, Waititu surrendered himself at Integrity Center on Sunday 28 July 2019 and was promptly arrested. On Monday, 29th July 2019, Waititu and his wife, together with others, were charged in Nairobi's Milimani courts with conflict of interest, dealing with suspect property, abuse of office, willful failure to comply with the law relating to procurement, and engaging in fraudulent practice and money laundering.
The first accused shall not access his office until this criminal case is heard and determined.
On Tuesday, 30th July 2019, Magistrate Lawrence Mugambi granted with strict conditions 15 million shillings and 4 million shillings cash bails, respectively, to Waititu and his wife.
There has been a debate gathering momentum in the country on the likelihood of a referendum. Will it be Punguza Mzigo? Will it be the BBI? There has been a discussion about the revenue allocation bill that is being pulled and pushed between Parliament and the Senate. What are Raila Odinga's views? What are ODM's views? But before we get into this in detail, Point Blank sought out our eminent lawyer, Otiende Amollo, who, of course, is known for having been at the Committee of Experts and much more, to help us decipher what is actually going on inside and outside Parliament on these and other issues. But before I speak to Mheshimiwa, what has he done before?
Otiende Amollo is serving his first term as the elected representative for Arieda constituency in Siaya County under the Orange Democratic Party, ODM, in the National Assembly. A holder of an LLB and LLM from the University of Nairobi in 1995 and 2004 respectively, Otiende was thrust to the public's attention as one of the 9 committee of experts led by Nzama Kitonga, who drafted and delivered the new Constitution of Kenya 2010. He would later serve as the country's first occupant of the office of the Ombudsman. Having successfully vied and won the Arieda parliamentary seat during the August 8, 2017 general election, Otiende would capture the public's attention as part of Senator James Orengo-led legal team that successfully petitioned the re-election of Uhuru Kenyatta as president following the highly contested presidential election.
Analyzing the results from when it starts to the end, it gives a very clear, straight line, which is a statistical impossibility. Using that formula, all you need to know is how many votes Prime Minister Raila has at any one time.
The fiery legislator is on record calling not only for a referendum to amend sections of the Constitution.
Now we need to concretize our ideas. We need to pass some legislation that guides that review. We need to form a team of experts who then can collect the various views from Kenyans and from various groups, and who then will also consider the question of how do we infuse the question of boundaries review of constituencies under Article 89.
Mheshimiwa, karibu sana and welcome.
Asante.
Welcome to Point Blank.
Thank you. Thank you.
Mheshimiwa, I regret that I have to start at a somber note. Yes. You lost a colleague, a member of your party, a friend, as he was mine. What are your first thoughts about the death of our brother, the MP for Kibra?
The late Honorable Ken Okoth was my friend, and when I learned of his passing on, I tweeted and described him in 3 words: brilliant, courageous, and selfless. Ken Okoth was certainly brilliant, and sometimes there's an aridity of intellectualism in politics. He was courageous enough to share the fact that he had cancer, courageous enough to share with the public the stages, and he had the ultimate courage to say that the machines that he was on life support would be switched off. He was certainly selfless, as the whole country knows, that he served with the people of Kibra and the entire nation with great dedication. He is one of those who certainly went into politics for the right reasons.
You know, as a friend of mine, I often ask Ken, you know, how are you going to fill these shoes coming from Jacom, from Baba, being the next immediate MP, or it was then Kibira, over to Kibra. How did he fit? Was he able to fit into the shoes as a second-term MP?
I think, obviously, Ken did very well. That's why he was re-elected to Kibra. But I think it also helped him. 2 things helped him. One, that he was born and raised in Kibra, in the slums. Secondly, during his entire political development, he understudied the Honorable Raila Amolo Odinga and maintained closeness with him throughout. And I think that greatly helped him navigate the Kibra politics and development.
Mheshimiwa, at 41, it was actually noticeable that his name elicited so much emotion across the political divide, across the age divide, across the gender. I mean, so many people felt touched by Ken. He had the Midas touch. Would you agree?
I would certainly agree. There are a number of things Ken had which were unique. One was the ability to serve the lowest in the slums and at the same time to engage in the highest intellectual discourse. The second thing he had was the ability to maintain unity within the party and the party line, but also independently navigate and get people to focus on development in Kibra. And I think those abilities made him stand out quite a bit.
Well, on my own behalf, on behalf of the team here at Point Blank, KTN News, the Standard Media Group, you know, our condolences go to the family, and I think they may take comfort that he left a mark. So may he rest, may he rest.
May he rest in peace.
Mheshimiwa, I want to start where Kenyans know you more. Obviously, the time of the petition, the presidential petition, you stood before the Supreme Court and argued very heavy and weighty matters relating to electoral outcomes in the country. And obviously with the handshake, that is water under the bridge. But simply as a matter of law, for students of law and keen observers of Point Blank, what were the salient issues that came out from, you know, from your encounter at the court? What were the principal issues of law adjudicated?
Well, there were many, but let me put it this way. From the many issues that were raised, that we raised, that other parties raised, and the court's decision, there are at least 2 or 3 things that stand out from a jurisprudential perspective. One is, until then, it was assumed that as a party, if you go to court, you must prove your case, and the respondent has no obligation to do anything. I think that case demonstrated that under Article 88 of the Constitution, it is required that the electoral body must conduct an election that is transparent, accurate, and accountable. And once it's called into question, the electoral body must also demonstrate that, and that is what the court did. That is why the IEBC was asked to open its servers and demonstrate how it arrived at the result, and it failed. That is very important, because until then, it was assumed that the IEBC or the electoral body does not have to show anything.
So this, for the lay observer, was not actually the court deciding on who won or lost the election. The court did not address itself to that issue. You're saying it addressed itself to the conduct.
The court did not address itself to that issue, and it needed not address itself to that issue. When we were writing the Constitution and we decided that presidential elections must come to the Supreme Court, the job of the Supreme Court is to look at the integrity of that election and come to the conclusion as to whether it passes the test of fairness, of accountability, of accuracy. And if it does, it will be sustained. If it doesn't, it must be nullified. And that's what happened.
Mheshimiwa, historians and judicial scholars going forward will review the conduct of the Maraga Court, being the first court in Africa to nullify a presidential election. Will history be unkind to the Maraga Court? Did it act properly?
I think that the Supreme Court did what few courts have had the courage to do. Very, very few courts in the world, and I think this was only the 3rd occasion in history when a presidential election has been overturned, to have the courage to say that someone who has been duly declared as elected was not properly elected. And I think the demonstration that history must judge that court favorably is when 3 weeks later, Justice Maraga went to Tanzania and the Chief Justices of the world were meeting there. They gave him a standing ovation. Chief Justices are very serious people. By the time they give you a standing ovation, they respect both the courage and the jurisprudence that comes out of that case.
Now, as we move on to the current time, my eye is drawn to this landmark ruling by Justice Mumbi, where she has ruled that an accused person who is holding office, in this case a governor, now as we track this case of Waitito, for example, and others that are in the courts, that you should actually, under Chapter 6 of the Constitution, be out of office for the period your trial is ongoing. What is your bird's eye view of that judgment?
It's an interesting one. First, as a matter of principle, it is a good principle of law and politics that if you are charged in a court of law with corruption-related matters, then you ought to step aside while that case is going on, as a matter of principle. However, secondly, that principle must be tampered with the reality. there are certain offices which becomes a bit difficult to exercise that in respect of. For example, right now, I know so many colleagues in Parliament who have been charged. And so the question is, should they step aside? But step aside from what? And what happens to the residents of that constituency in terms of representation? So it is a good principle, but it is one that must be based on case by case. In this case, it should not be misunderstood, and this is important. Justice Mumbi Ngugi was exercising her discretion on a particular case. The question was not constitutionality generally of that provision, but she took the opportunity to comment on it. Moving forward, whenever anyone is charged, whether it's a governor, whether it's any other person, it is up to the trial court to decide, as sometimes they have, as happened in that case, whether that person should step aside or not.
I'm asking this question because last week I had your senior brother, James Agriorengo, here, and he was saying that there is a distinction between an appointed cabinet secretary and somebody who has been elected and is holding office, either as a governor or any other elective office, be an MP, and that by that fact of being elected, the court would need to work, in a more reluctantly for the reasons of representation. Now, if corruption becomes the norm, as it is now, and governors continue to mess up evidence because they've got access to the offices and the people with whom the prosecutor would need to talk to adduce evidence, what is going to be the, the legal precedent if the Mumbi matter is to be taken into the context of the Economic Crimes Act, in the context of the Chapter 6, how will that relate going forward if you were to predict the jurisprudential journey?
There's certainly a distinction between elected and appointive officers, and that distinction is made by Section 62 of the Anti-Corruption and Economic Crimes Act. That distinction is what Justice Mumbi Ngugi was trying to bring down, and she was suggesting that there ought not to be a distinction. But even for appointive officers, there's also a distinction between those whose offices are protected, like judges, and those whose offices are not protected. I think the point is, and I think this point has been made before, for the appointive officers, where there's no protection, like a cabinet secretary, when an issue of corruption has arisen, even before you await the criminal responsibility, there ought to be a political responsibility by stepping aside or being removed from office, because the president has that discretion. There are then the appointive officers for which there is protection, like judges. Now, those ones also are regulated to the extent that if you are charged, then you are on half salary, you're under suspension and that kind of thing. The murkier one moving forward is to take the suggestions by Justice Ngugi to its logical conclusion. And I gave you the example of a member of parliament. It gets murkier. If it is a governor, the truth is many governors work hand in hand with their deputies. So moving forward, you are likely to have situations where there's a governor and the deputy both charged at the same time. So the question then becomes, who then is left to govern that county? Now, logically, then the speaker of the county will come in. But the speaker of the county comes in, and it's supposed to be for a limited period under the Constitution. And so the question would then be, if they step aside, both of them, for the length contemplated by the Constitution, do you end up in fresh elections or not? So there are a lot of things around that require this discussion. So as we say there should be no distinction, we should bear in mind that sometimes people hold office not for their own, but for the benefit of
Let's
those
talk then about the conduct of accused persons or people who are required to be before the court. I found it quite dramatic, and I'm sorry to use the word careless, for the governor of Kiambu, Waititu, to go into hiding, or, to literally force a manhunt by the Ethics and Anti-Corruption Commission. Is that the kind of behavior envisaged when leaders say, why can't we just be invited to come? Is there not now evidence that if you don't ambush and surprise these people, that actually law enforcement will find it hard.
You know, Tony, for the longest time, I've been an advocate of decorum. Thorough investigations, and then when you are required, and this is how it used to happen, you are told, we have investigated you, we have evidence to charge you, we want you to appear in court 1 tomorrow at 9, and prosecutor would be there. If you don't appear, then a warrant of arrest issues immediately. But the kind of conduct we have now seen of Governor Waititu and others trying to go into hiding lends credibility, unfortunately, to the idea of ambush, which is unfortunate. But I think governors and anyone who's sought by the police must be advised. You can never run in this current world, because where will you go? And somebody in the caliber of a governor, where will you hide? Even if you try to get out of this country, you will still be brought back. And unfortunately, it then becomes a factor in considering bail, because you've demonstrated that you're a flight risk, and you make the court, therefore, be inclined not to grant you bail than otherwise.
Let's talk then about the strategy of the prosecutor, because the prosecutor in this case, and we can speak about him a bit more, Taib, had come to court not opposing bail. In fact, been very flexible on bail terms. In terms of the prosecutorial strategy, number one, of decorum, meaning you interact and inform and hope you get cooperation. That's on one. Number two, where you now expand the investigation beyond the person to the family as a strategy of ensuring that this man can't escape. Does that maybe lead to why Waititu was apprehensive? Because he's not charged alone. He's charged with his wife. And maybe it was a Friday and...
There are two issues there. Let's talk about the idea of charging the family. As I understand it, it's not quite a question of the strategy, but it's a question of where, and many people do that, many public officials do that, where you form companies and involve your wife and children, and then those companies end up being involved in things that are criminal. When then you are held to account, you must expect that all those who you had involved must be held to account, and that includes your wife and children. And there's absolutely nothing wrong with that in law and fact. So, secondly,
yes,
the question of the approach by Ali Taib, especially in the charges of Aror and Kimwarer, I think it was a decent thing he did. The Constitution presupposes that everybody has a right to bail, unless there are exceptional circumstances. And time and again, we've had cases where the question of bail becomes the trial itself, and it becomes a diversion. Any good prosecutor who has put their evidence together, usually, unless there's exceptional circumstances, will not want to spend time on bail. They'll tell the court, we have no objection to bail, just make sure that you impose terms that will ensure that the accused attends trial. So what he did there was a very good thing, and that's what we've always emphasized.
Restricting travel.
Restrict travel, reasonable bail times,
yeah,
and then focus on the trial, do it as quickly as you can, let the guilty then serve their sentence.
Let's ask you to look into the magnifying glass, into the mind of Haji. In the case of Waititu ongoing now, he has said that the daughter was involved in companies that are subject to the charges, but he has singled out the daughter as a sleeping director, but has involved the wife and the husband in the enterprise, the illegal enterprise that he wants the court to address. What would inform a prosecutor, in your mind, to leave one director? Is it because he's a daughter, or what is a sleeping director?
The approach by the DPP Haji on that one is the correct one, and it's something I've been urging for the longest time. I have criticized DPP Haji that for very many cases, he brings too many people to court with too many charges. And whenever you bring like 50, 60 people to court, and the charges are like 100 or 50 or 70, chances of all of them going scot-free is very high. You must always look at the highest culpability. Take a few people who are most culpable, solidify the evidence and solidify the charges, and you'll get them. So that is the right approach. However, the other aspect of DPP Haji that sometimes brings to question is sometimes he tends to prosecute his matters too much in the media and not in court. And I have a problem with that. I have a problem with a prosecutor who is media savvy but court shy. I want a prosecutor who will say to the public what he will tell the court, but not who will tell the public this and raise expectation, but then not go to court. Because if then the court fails, people tend to blame the court. But you have not given the court what you promised to give.
I'm asking you this about the prosecutorial strategy because in the previous week, when Henry Rotich was charged with Dr. Thuge, there was more than 26 accused persons on relatively similar charges. And those were robust, including foreigners. And I know we will discuss the element of foreigners, a different segment. But the fact that he is able to say that he is charging some directors and not another director, and on the other case, there is a maximum charging, I wanted to know whether there's a consistent philosophy. Does Haji have a philosophy?
Well, we would not quite know. You know, my brother, the DPP, does not tend to prosecute his cases in court. I think he's one of the DPPs who have not seen appearing in court. So it's difficult to decipher his legal philosophy. However, it is true that there's some slight deviation in philosophy in those two cases and the earlier ones. And I think the latter philosophy is the better one. Get a few people who are most culpable and then charge them and have them convicted. Because if you get all and sundry, including people who may have assisted, you know, it's like this. Somebody could steal from this hotel, and then in the course of it, they get into a matatu, and the matatu does not know who's there. If you get the person who stole, the person who assisted him, then you charge the driver of the matatu, you charge the conductor of the matatu, you are losing it. Let the driver and the conductor be witnesses rather than accused persons. So the latter strategy is the better one.
Now, let me ask you, in terms of the overall government strategy for corruption, you had the case of Henry Rotich and Dr. Thuge go to the DCI offices and be charged by the Director of Criminal investigation or report to the DPP. And on the other hand, you've got the Waititu case, where it's the Ethic and Anti-Corruption Commission that has done the work and recommended to the DPP. Why is there a difference in the two cases that one falls under the ambit of the Ethics Anti-Corruption Commission and the other one falls under the Directorate of Criminal Investigation?
I think there we must juxtapose the constitutional expectation against the reality. The constitutional expectation was that the Ethics and Anti-Corruption Commission will be the premier body in terms of fighting corruption. The reality became that the EACC was not doing its work. And that is why President Uhuru Kenyatta found it necessary to revamp DCI and the DPP. Now, the reality then became that the DCI and the DPP now tended to be the focus of the fight against corruption. The good thing about that is that it has awoken the EACC from slumber. And now they are taking the courage to pursue cases that they might not have pursued before.
So the law does not differentiate who originates the criminal inquiry?
The law does not.
As long as it's before the DPP?
What the law does is determine the ultimate person to determine whether you are charged or not. That's the DPP. So it can be from EACC, it can be from DCI, it can be from you, it can be from the Auditor General, it can be from anybody, provided it's well investigated and it lands at the DPP, and then the DPP takes the charge.
So an ordinary Kenyan should not be wondering at home why Rotich was not hosted at the anti-corruption offices at Valley Road,
I think what
as opposed to Kiambu Road.
What the ordinary Kenyan should do is celebrate, because corruption has become endemic. And therefore, fighting corruption from all angles and all agencies is a good thing. If this can help reduce corruption, then that is a good thing.
This man, Haji, do you know him? Is he driven?
I have not known personally DPP Haji, because he's one of those lawyers who has not quite been in practice of law. In fact, to the best of my knowledge, I do not think he has usually practiced in court, even before he was appointed, which might explain why he's a bit court shy. But the one thing I can see from all his endeavors is that he has the courage to go for anybody, irrespective of your station, and that is a good thing. Secondly, he has the drive. Thirdly, he endeavors to keep the public posted. Yes,
In the original case that started all this, it was the Rotich case, and Enter Taib, the former mayor, he became almost the face with a beard and obviously eloquent in court. Have you traded cases with him in court? Have you argued with him?
In my over 2 decades of practice, yes, we have. We've had engaged in a number of cases, especially when he was practicing in Mombasa. And yes, he's a passionate lawyer, and obviously lately a man of character. He was not always that man of character with the white beards and all that. But the point of it, though, is this. However good Ali Taib is, his approach is right. But when you go for high cases, like now you're prosecuting the minister for finance, or earlier when they were prosecuting the Deputy Chief Justice, you need the person who was approved by Parliament to be the chief prosecutor to do it. You need Kenyans to see that we appointed this man as our DPP to prosecute and is now prosecuting. If you keep delegating, then it begs the question, were you the proper person to be approved as the prosecutor? Or is it that other person you are delegating to? DPP Haji is doing the right thing, his mind is in the right place, but he must gather the courage to be in court and prosecute.
From where you sit, is there some change from the state of the nation? Is something happening on the war against grand corruption?
It is clear that something is happening when you have the Minister for Finance, and I think they were saying that's the first time it has ever happened, certainly in this country. You have the PS Finance and a host of senior officers arrested and arraigned while serving. That tells you that something is happening. From the grapevine, they say that more arrests are on the way. However, I said this when President Uhuru addressed us at the National Assembly on the State of the Nation address. He said that he would not act until people are arraigned in court, then they will be suspended. From where I sit, I think the president owes to Kenyans. Anybody in respect of whom there's a whiff of corruption, especially when they're ministers or in appointed positions, you do not have to wait until they are arraigned in court because there's no such requirement. You can suspend them or you can remove them. The way that President Kenyatta must now go a notch higher. The idea of being arraigned in court is for criminal culpability. He needs not await criminal culpability. He has a lot of intelligence. And you know, with corruption, sometimes you can have evidence which cannot be produced in court. If you have that evidence, remove that person and bring in somebody else who everyone knows will not succumb to corruption.
Well, you're watching Point Blank here at the Nairobi Serena. And Otiende Amollo says that it's not enough for Noordin Haji to delegate. He should be in court himself. And then he says to Kenyatta, it's time for you yourself to walk the talk and fire ministers who have any blemish of corruption so that they are cleared before they return. This is Point Blank. You're watching KTN News.